All right, guys. So today I'm going to go through the full lawsuit, this complaint that Patagonia, the clothing company, filed against Pattie Gonia. Okay. And Pattie Gonia is a drag queen, climate activist, community organizer, 3.7 million raised for nonprofits. Okay. So Patagonia, the clothing company, filed a lawsuit for trademark infringement, dilution, and unfair competition. Action seeking statewide or nationwide relief, jury trial demand. So they file a lawsuit for monetary damages of $1 against Pattie Gonia, right? But then they want some other stuff. So we're going to go through this. I'm not a lawyer, so if you're a lawyer, chime in here. All right, I'm not one. So that may lead to the question, well, why are you on here talking about it then? Well, because my wife certainly doesn't want to hear me break down the Pattie Gonia lawsuit paragraph by paragraph, and my buddies don't want to sit here and listen to me do it either. So this is 37 pages long. We're going to go through this, and so you guys, it might take a little bit, tuck in, grab a drink. Let's get it started, okay? So here you go. United States District Court for the Central District of California, Western Division, Los Angeles, all right? Complaint for trademark infringement, dilution, and unfair competition, all right? The plaintiff is Patagonia, and the defendants are Entrepreneur Enterprises, Pattie Gonia Productions, and Win Wiley, which is Pattie Gonia's name. All right, introduction. Plaintiff Patagonia brings this action against Entrepreneur Enterprises, DBA Pattie Gonia Productions, and its owner Win Wiley, collectively Pattie Gonia or defendants, in response to defendants' recent trademark application claiming the exclusive right to the brand Pattie Gonia for, among other things, apparel, online marketing services, promoting public awareness of, and motivational speaking services in support of environmental sustainability and LGBTQIA2S+ equality, organizing community sporting and cultural events, organizing, arranging, and conducting trail and hiking events, entertainment services in the nature of live musical performances and music recordings. So this is in response to defendants. So Pattie Gonia tried to put in a trademark application claiming the exclusive right to the brand Pattie Gonia, not Patagonia, Pattie Gonia, okay, for all these things. So Pattie Gonia wanted a trademark for all this, organizing community sporting events, conducting trail and hiking events, musical performances, all that. These products and services compete directly with the products and advocacy upon which Patagonia built its Patagonia brand over the last 53 years. All right. The trademark application reflects Pattie Gonia's departure from discrete use of a persona to engage in activism and confirms defendants' intent instead to launch a wide-ranging commercial enterprise under the Pattie Gonia brand. So there's a lot of thoughts on this, right? Because we got LGBTQ involvement. There's a whole thing. Pattie Gonia is a loud, vocal drag queen, climate activist. So there's a lot of feelings about this lawsuit, right? And the initial feeling, obviously, is against the evil corporation, right? Patagonia, how can they trademark anything? Blah, 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 blah. So we're going to look into this here. So right now, Patagonia is saying that Pattie Gonia's departure from discrete use is you post in, no monetary ties, whatever, you're just having fun with it. And instead, they're saying Pattie Gonia is trying to launch a wide-ranging commercial enterprise. So now you're trying to make money with it, right? Under the Pattie Gonia brand. And this enterprise contradicts defendants' prior promises and appropriates Patagonia's brand and identity in a way that has already confused consumers. Sure, Patagonia, Pattie Gonia, it might be a little confusing, and will continue to confuse consumers about Patagonia's role in producing or sponsoring Pattie Gonia's products, events, and public appearances, okay? So initially, they're saying that because Pattie Gonia is about to make this commercial and start making money from it, this is going to cause all kinds of confusion in the marketplace as far as what's Patagonia, what's Pattie Gonia, are the two tied together? Obviously, the names sound similar, so people are going to think one's tied to the other one. Sponsoring Pattie Gonia's products, events, and public appearances. Patagonia supports advocacy and activism that promote the environment and inclusion in the outdoors, central to Pattie Gonia's ostensible mission. So they're saying we support the mission that you're on, this climate activist, the hiking, all this stuff. We support all that, okay? For that reason, before Pattie Gonia's activities and identity transformed into a commercial enterprise, Patagonia repeatedly communicated with Pattie Gonia and understood that the parties had reached agreement about how that advocacy work might continue in a way that would not interfere with Patagonia's brand. Okay, so Patagonia, the brand, is saying, we're with you. We're not against activism. We're not against a good cause. We're here for it, right? And before, you were doing this for fun. And we've talked to you. We support advocacy. We repeatedly communicated with Pattie Gonia, understood that the parties had reached agreement about how that advocacy work might continue in a way that's not interfering with Patagonia's brand, right? Basically saying, if you're not making money off this, you're okay. Pattie Gonia has not honored the agreement, however, and now seeks exclusive ownership of a Pattie Gonia trademark to commercialize products, endorsements, marketing campaigns, and advocacy. For all these reasons, Patagonia must protect its iconic trademarks, even when it supports or agrees with Patagonia's views, message, or objectives. Okay? Defendant's trademark application followed the launch of a commercial website, PatagoniaMerch.com, in late 2024, selling Patagonia branded apparel. This website looks like this today. So this to me is very interesting. This is more than just evil corporation bad, right? So the corporation's coming out saying, we are not against what this person's doing. We're not against Pattie Gonia. We're not against the activism. They're saying we have to protect our trademark. We have to protect our brand trademark. Okay, interesting. So here's this Pattie Gonia merch, right? Here's what it looks like. Nature is Gay tee, $48. Patagonia Hiking Club, right? Here it is. Here's the merch. 75 bucks. Okay, so that's what some of the merch looks like, okay? Page 4. The examples below show the extent to which Patagonia has associated the party's brands, integrating Patagonia's logo and branding into the Patagonia persona and related business enterprises. So here we go. Only a few more variants until Patagonia. So here's this logo, Patagonia, right? And here's Patagonia, the influencer, the activist. Right there, you can see the designs. Right? Slut for nature. Okay. And then there's a glove right there. Right here. So you guys can kind of see what this branding looked like, right? Okay. Consumers are already confused about whether Patagonia is affiliated with Patagonia. For example, consumers have made the following comments in response to Patagonia's social media posts. It looks like Patagonia has it together. I'll happily spend my money there. Last summer, former Patagonia CEO David Olson came through my coffee shop. He was so nice and complimented the boutique. Yep, if Patagonia ever falls, I'm gonna cry. Yes, it's expensive, but their warranty is literally the best. So here's some comments, and then here's some more comments. I genuinely thought this was a Patagonia ad for too long, or is it? Love you, Patagonia. You're amazing. Thank you for protecting our parks. So they're saying that this is confusing the people. The people don't know if it's Patagonia or Patagonia, right? What's what? It's a big whodunit, okay? Patagonia tried to work with Pattie Gonia to avoid this outcome. In February 2022, when Hydro Flask was discussing a collaboration with Pattie Gonia, Hydro Flask contacted Patagonia to ensure Patagonia did not object to the proposed collaboration. The parties met and discussed restrictions on the use of Pattie Gonia to protect against confusion about the source of products or advocacy connected to Pattie Gonia. Pattie Gonia confirmed an understanding that she must refrain from selling Pattie Gonia branded products or using fonts or designs that copy or are substantially similar to Patagonia's logos. Okay, so here we go. Pattie Gonia confirmed an understanding that she must refrain from selling Pattie Gonia branded products or using fonts or designs that copy or are substantially similar to. So that's key, okay? Ultimately, Pattie Gonia ignored the agreement she had reached with Patagonia and began selling the products under the Pattie Gonia brand. In early 2025, after seeing Pattie Gonia selling Pattie Gonia branded apparel on Pattie Gonia's PatagoniaMerch.com website, dude, say that 12 times fast, Patagonia again asked that defendants stop, commercial use of the Patagonia name and abide by the 2022 understanding. So they're saying in 2022, when this got on our radar, we had come and talked to you and said, look, Patagonia, obviously this is going to cause some confusion. If you're not making this commercial, if you're not making money off it, okay, we'll be okay with it because you guys are doing a thing, you're an activist, we got it. We got what you're doing. So now Patagonia, then obviously in 2025 or 2024, tried to file an application to trademark then, to commercialize this Patagonia brand, right? And so now Patagonia is saying, whoa, now we've got to get involved because this is our trademark, okay? And they're saying we had an agreement in 2022, we talked this out, we had an agreement, and now you're kind of going back and reneging on that, right? Reached in February 2022. Patagonia restocked a full line of Patagonia apparel and filed a trademark application confirming Patagonia's intention to secure rights in a competing and confusing brand used to sell many of the same types of products and services that Patagonia has offered for decades. Guys, honestly, this kind of makes sense to me. If your name is Patagonia, people are gonna think maybe they don't, but if they think you're affiliated with anyone, they're probably gonna think you're affiliated with Patagonia. Maybe not, but I can see the confusion argument. I'm just saying I can see how it would be confusing, okay? Despite Patagonia's efforts to avoid this dispute, it is left with no choice but to seek relief from the court due to Patagonia's refusal to honor the parties' prior understandings. The commercialization of the Patagonia brand, the use of the brand on confusingly similar products and services, and Patagonia's use of Patagonia's logos. To prevent further damage to consumers, Patagonia and its brand Patagonia further alleges as follows. So they're saying, this is an interesting thing, is by the time this comes up in the public, by the time we're seeing this has already been going on in the background for a number of months, sometimes even years. So they're saying, right, so it's easy to be like, oh, corporation bad, brand bad, but Patagonia here, the company, is saying, we've had these discussions in the background, aside from the public eye. Years ago, we've had these discussions. We seem to have had an understanding. Now this person, Patagonia, is going in a different direction, and now we have to protect our brand and our trademark, okay? I don't know. What do you guys think of that? To prevent further damage to consumers, Patagonia and its brand Patagonia further alleges as follows, okay? Patagonia Inc., a California corporation headquartered at Ventura, California. Patagonia has been designing, developing, marketing, and selling outdoor apparel, accessories, and active sportswear for nearly 50 years. Patagonia's Patagonia brand and P6 logo are famous in the United States. They're setting up their case here. They're describing what's going on. Famous in the United States and around the world, and instantly recognized by consumers as a symbol of innovative apparel designs, quality products, and environmental and corporate responsibility. 2. Defendant Entrepreneur Enterprises, DBA is doing business as Patagonia Productions, is an Oregon corporation with its principal place of business in Bend, Oregon. Patagonia Productions applied on September 1, 2025 to register Patagonia as a trademark, serial number 99404, in 5 classes: recorded music, stickers and posters, clothing, marketing service, and entertainment comprised of live music, performances, motivational speaking services in the field of equality and environmentalism. Okay. Defendant Win Wiley is, on information and belief, an individual residing in Bend, Oregon, 97703. Wiley is the founder and owner of Entrepreneur Enterprises, DBA Patagonia Productions. Wiley has developed, controlled, and implemented the Patagonia persona, brand, and has personally directed the use of Patagonia's logos and branding. 4. Entrepreneur Enterprises, DBA Patagonia Productions, and Win Wiley are collectively referenced in this complaint as defendants or Patagonia. 5. Patagonia's trademark claims arise under the Trademark Act 1946 as amended by the Trademark Dilution Revision Act of 2006. This court has jurisdiction over such claims pursuant to 28 U.S.C. and Trademark and Federal Regulation. This court has jurisdiction over state law claims. 6. This court has personal jurisdiction over defendants because defendants have purposefully availed themselves of the privilege of doing business in this district. Patagonia markets, sells, and ships products bearing the Patagonia trademark to residents in this district. Patagonia has performed under the Patagonia name in this district, including at the Bellwether Theater in Los Angeles in June 2025. On information and belief, Pattie Gonia sold Pattie Gonia branded products to residents of this district in connection with such performances. So they're saying Pattie Gonia's been out doing shows, performances, selling all this merch, speaking tours. Pattie Gonia branded products. Pattie Gonia also filmed multiple episodes of the Go Gently television program in this district, including episodes in Los Angeles and Ventura, California. Venue is proper in this court, and because Pattie Gonia infringes Patagonia's intellectual property in this district, transacts business in this district, and a substantial part of events giving rise to the claimed asserted arose in this district. So they're saying why they're doing this in Oregon there. Factual allegations common to all claims. So this is factual allegations common to all claims. Patagonia's history. Patagonia was founded in late 1960s to design and sell climbing clothes and other active sportswear. So they're going to basically give a breakdown of who they are. The company adopted the brand Patagonia to differentiate a related business that designed and manufactured climbing gear and tools. Since at least 1973, the Patagonia brand has appeared on a multicolored label inspired by a silhouette of the jagged peaks of the Mount Fitzroy skyline, the P6 logo, okay? In the 50 years since Patagonia's business started, the Patagonia brand and its P6 logo have become amongst the most identifiable brands in the world. Patagonia's products now include a wide range of apparel products, so they're setting up their case around this logo. Wide range of apparel products and equipment, including t-shirts, hoodies, sweatshirts, and fleece, as well as technical products designed for climbing, skiing, snowboarding, surfing, fly fishing, and trail running, which are sold around the world. In 2012, Patagonia launched Patagonia Provisions, a food business that promotes responsible sourcing and regenerative solutions in fisheries, agriculture, and land stewardship. As part of its long-standing commitment to the environment, so I like how they're throwing in how they're definitely not, they're not against this climate activism. They're like, we're part of this thing. We're for it. We're for what you're doing, right? We're not against climate activism. In the 50 years since Patagonia's business started, wide range, okay. As part of its long-standing commitment to the environment, Patagonia also produces books, films, and educational awareness materials that are distributed through bookstores and theaters, in addition to its website and social media channels. Patagonia has published books including Tools for Grassroots Activists and a second edition, Tools to Save Our Home Planet, a guide for effective environmental advocacy, and The Responsible Company, which chronicles Patagonia's approach to responsible business practices and corporate citizenship. So they're lining out their community work here. Patagonia's films include New Talk, documenting America's first climate-displaced community, Public Trust, which explores the fight over America's public lands, and Artificial, which exposes the threats to river ecosystems from hatcheries and dams, and the impacts of ocean fish farms. Patagonia has also produced Why Plastic, which investigates the apparel industry's dependence on plastics, as Damnation, which highlighted the negative ecological and climate impacts of dams. 11. To further engage its community in activism, so they're saying we are activists. We are also activists. Patagonia is also an activist. To further engage its community in activism, Patagonia launched Patagonia Action Works in 2018, a platform to connect the hundreds of nonprofits that receive grants from Patagonia each year. See more below, with our community of activists who are looking for a place to connect with events, donate their skills and money, and sign petitions. Since the platform was launched, more than 500,000 people have provided over 2 million actions to 3,000 organizations. In 2025, Patagonia co-founded Brands for Public Lands, which now includes 100 companies representing 62,000 employees across 28 states and more than $19.9 billion in revenue, to amplify the voice of the outdoor industry against multiple attempts to roll back protections on federal public land. They're pushing this. We are also activists. We are here. We are also activists, right? Over the years, Patagonia has been recognized and honored for its business initiatives, including receiving the Sustainable Business Council's first Lifetime Achievement Award, the UN Global Climate Action Award, and B Lab's Best of the World B Corp Award. In 1996, with increased awareness of dangers of pesticide use and synthetic fertilizers used in conventional cotton growing, Patagonia began exclusively using organic cotton. In 2017, Patagonia helped establish the Regenerative Organic Certified Program, a holistic agriculture certification encompassing pasture-based animal welfare, fairness for farmers and workers, and robust requirements for soil health and land management. In spring 2022, Patagonia released its first regenerative organic certified products. Patagonia has also worked to remove virgin synthetic materials from its product line And as of 2025, 93% of the polyester in its products is recycled, while 89% of the nylon is recycled. Beginning in 2025, all new Patagonia products are made without intentionally added PFAs. So this is interesting because if anybody goes to read this, the public uproar becomes, oh, Patagonia is a corporation, Patagonia is bad. But if you actually go in and dig in and read the lawsuit, Patagonia wants you to know, no, we're out here too. We're out here doing the same thing. We're activists also, right? Patagonia was a founding member of the Fair Labor Association, which is an independent, multi-stakeholder verification and training organization that audits apparel factories and now includes over 200 members. In 2014, Patagonia began partnering with Fairtrade USA, through which Patagonia pays a premium that goes directly to factory employees making its products. We're a good company, guys. We are not the corporation to hate. And look at all these things. We're going to tell you why. This year, 95% of Patagonia's line was made in Fairtrade certified factory, impacting more than 85,000 people in Patagonia's supply chain. Patagonia has paid $37 million in Fairtrade premiums to those making its products since the program began. Additionally, since 1985, Patagonia has pledged 1% of sales to environmental groups to preserve and restore our natural environment, donating more than $250 million to date. In 2002, Patagonia's founder, Yvon Chouinard, along with others, created a nonprofit called 1% for the Planet to encourage other businesses to do the same. Today, 1% for the Planet members have donated more than $820 million to as many as 4,400 eligible organizations that are fighting climate change. In 2012, Patagonia became one of California's first registered benefit corporations, ensuring Patagonia could codify into its corporate charter consideration of its workers, community, and the environment. During its 2024 B Lab certification, Patagonia obtained a B Impact score of 166, more than triple the median score of businesses who complete the B Impact assessment. In 2022, Patagonia's owners restructured the company by giving away all their stock to entities designed to do two things: put those assets to work fighting the climate crisis and protect the purpose of the values of the company forever. The new owners of the company became the Patagonia Purpose Trust, protecting the purpose and values of the company, and Holdfast Collective, putting the stock and future profits to work fighting the climate and ecological crisis. Since this new structure was created, Holdfast Collective has committed to more than $180 million towards projects fighting the climate and ecological crisis. This is interesting. So this is all the stuff that they're doing behind the scenes. Well, us guys probably don't even know they're doing it, right? So whether one of this is true, they're listing out the things that make the company not look as bad as the public always looks at the corporations, right? Patagonia's trademarks. Patagonia owns numerous trade registrations for its distinctive Patagonia trademark and P6 logo, covering a wide-ranging assortment of products, including all the products and services covered by Patagonia's trademark applications. Among these are the following. So this is their trademarks here. This stock word, men and women's clothing, namely sweaters, rugby shirts, walking shorts. This logo with the mountain, men, women's, children's clothing, namely jackets, pants, vests, gloves, pullovers, cardigans. This logo without the Patagonia wording, and then this wording here. Men's, women's, and children's clothing, computerized online ordering activities in the field of clothing and accessories, providing information in the field of technical clothing. So this is trademarks. And over here it says when they were first used. So 1974, 74 to 81, 74 to 81, 95. Patagonia.com, online retail store and mailing order service featuring technical clothing, footwear, accessories. And then this Patagonia in education and entertainment services, namely organizing and conducting ambassador programs and related events in the nature of recreational activities. So all these similar things that Pattie Gonia is trying to trademark for here. Providing panel discussions in the fields of environmental issues, climate change, regenerative agriculture. And then Patagonia here, retail store services featuring clothing, footwear, luggage. Patagonia stickers, paper banners, fiction and nonfiction books. This looks like a lot, but really, if you're a brand as big as Patagonia, you're going to have tons and tons of different trademarks to make sure that everything you're posting, down to the signature in their email, is legal, right? Patagonia, Patagonia books. They don't want anybody else to be able to do this. They're a big company. They don't want you to just be able to take their logo, take their branding, and just stuff it on your own stuff. Fair? Fair. Patagonia books, books primarily in the field of biographies, discovering and appreciating nature, surfing, rock and mountain climbing, publishing of printed matter, books and electronic books, Patagonia Films here, entertainment services, distributing and presentation of films, and production and distribution of videos in the field of sports, current affairs, entertainment, and lifestyle. Patagonia Stories, entertainment services, namely providing podcasts in the field of environmental news, causes, and activism. Entertainment and education services, namely providing a website featuring information and non-downloadable articles about the environment and activism. So here's this logo right here. These registrations for Patagonia's trademarks and logos are in full force and effect. So they've been going. The registrations have become incontestable under 15 USC, a color image, so it becomes, you can't contest them. They've been going, we've got these trademarks, and you can't do anything about it, right? A color image of the P6 logo as follows, right here, Patagonia. Collectively, these marks, Patagonia's other registered trademarks, and its common law marks are referred to as the Patagonia trademarks. The Patagonia trademarks are distinctive, arbitrary, and fanciful, entitled to the broadest scope of protection, and certain of the Patagonia trademarks are registered worldwide. For many years before any use of Pattie Gonia or defendants' other related logos challenged in this complaint, Patagonia annually and continuously has spent an enormous amount of time, money, and effort advertising and promoting the Patagonia trademarks are also advertised and promoting the products on which its Patagonia trademarks are used. Patagonia brand products are advertised and promoted through a variety of channels and media, including in print and on the internet. In addition to advertising by Patagonia, the Patagonia trademarks are also advertised and promoted and presented at a point of sale by numerous authorized retailers. Okay? Consumers, accordingly, are exposed to the Patagonia trademarks in a wide range of shopping and post-sale contexts. In addition to media, Patagonia earns from its commitment to environmental justice. So they're saying that this trademark and these logos are presented at a point of sale, in our stores, outside of the point of sale. And so the customers are exposed to this logo. It's not like this logo is some tiny thing that nobody ever sees. The customers are continuously exposed to this logo, okay? Patagonia has sold its Patagonia brand products and distributed its Patagonia brand services all over the world, including throughout the United States and California. Through its promotion and investment in its brand and extensive sales, publicity, awards, and leadership, trying to minimize the environmental impact of its business, Patagonia has acquired enormous goodwill in its Patagonia trademarks. So what they're setting up is they're saying, we've done a lot here. This trademark is not just a logo. When people see the logo, they have an image of what this brand is. We've acquired enormous goodwill, right? The Patagonia trademarks are famous within the meaning of the Trademark Dilution Revision Act, enjoy strong consumer recognition. So consumers know when you see that logo, your brain is thinking Patagonia. And are recognized around the world and throughout the United States by consumers as signifying high quality products made by a responsible company. Okay? So they're saying when people see this, they have an image of what they're seeing. When you see the Patagonia logo, you associate it with the company Patagonia, a good quality product, and all of the things that we know or that they feel we should know about Patagonia, right? They're saying that our logo, when you see it, you have a certain image you're creating in your head. Defendants' infringement of Patagonia's rights. Contrary to Patagonia's 2022 commitment to respect Patagonia's trademark rights, and notwithstanding Patagonia's objections and warnings, Pattie Gonia has adopted and used Pattie Gonia, a nearly identical copy of Patagonia's Patagonia wordmark, to identify defendants as a source of a wide range of products and services as outlined in defendants' trademark applications, including apparel, online marketing services, promoting public awareness of and motivational speaking and services in support of environmental sustainability and LGBTQIA2S+ equality, organizing community sporting and cultural events, organizing, arranging, and conducting trail and hiking events, entertainment services in the nature of live musical performances and music recordings. These uses of the Pattie Gonia brand inevitably imply to consumers that Patagonia has endorsed or authorized these products and services. As expected, confusion has already occurred, or that the products and services are the result of a collaboration between Patagonia and Pattie Gonia. So they're saying when Pattie Gonia puts this name and logo and merch and all this stuff out there, people are confused. They're thinking, obviously, Patagonia is related to Patagonia. And so the image in your head is created as such, as you're lumping these two entities together. That Patagonia is saying they're not together. The Pattie Gonia branded products and services are referenced in this complaint as defendants' Pattie Gonia products. Examples of Pattie Gonia products follow. So here's a couple of the shirts. This is Pattie Gonia merch now. Pattie Gonia Hiking Club. Here's this. Here's the merch. Some more merch. Pattie Gonia right here. Okay. While defendants only recently have A, commercialized Patagonia as a brand, B, promoted Patagonia apparel releases, including through PatagoniaMerch.com, and C, filed an application for trademark at the Patent and Trademark Office, Patagonia first addressed this potential conflict in February 2022, when it was raised by Hydro Flask, which was then a potential Pattie Gonia collaborator. So Hydro Flask was going to collaborate with Pattie Gonia, the climate activist, and Hydro Flask reached out to Patagonia, okay? At that time, as explained below, Patagonia shared concerns with Pattie Gonia and reached an understanding that Pattie Gonia would not commercialize the name as a brand. So that's pretty self-explanatory. So at the time, Patagonia, the company, reached out to Pattie Gonia and said, hey, we're concerned here that this is going to cause some confusion in our brand, yada, 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 and reached an understanding that Pattie Gonia would not commercialize the name as a brand. In early 2022, Patagonia learned that Pattie Gonia was planning fundraising partnerships with outdoor accessory and apparel companies Hydro Flask and the North Face, one of Patagonia's top competitors. So 2022, a little birdie told Patagonia, told Johnny Patagonia, that Pattie Gonia was going to do a collab with one of Patagonia's competitors. Hydro Flask was concerned that Patagonia might view this type of promotional work under the Pattie Gonia name as likely to confuse consumers about an association between Hydro Flask and Patagonia. Hydro Flask consequently reached out to Patagonia to discuss the proposed collaboration. I think this is interesting because, it's like, oh yeah, they're our top competitor. But in the business world, like in our business, I talk to my competitors. We have a good relationship. We go to lunch, we talk. If we're competitors, do we like each other? We like each other, but we're still competing. So underneath it all, these companies do communicate. They're all talking to one another, right? Hydro Flask, all three parties met, and Patagonia explained Patagonia's need to protect the Patagonia trademarks, including while trying to leave space for Patagonia's fundraising in support of environmental causes. While trying to leave space. So Patagonia is saying we have to protect our trademarks, but we want to leave space for your cause, requiring that Patagonia refrain from using the term as a brand or source indicator in any collaborations or commercial activities. At the conclusion of those discussions, Patagonia and Pattie Gonia reached an understanding memorialized in emails dated February 9, 2022, February 10, 2022, and February 15, 2022. Those emails with some personal identifying information redacted are reproduced below. Okay, so here we go. February 9, 2022, email from Patagonia. Subject, Hydro Flask, Pattie Gonia / Patagonia. Hi all, Pattie. Thank you for the call today, and I really appreciate the time and thoughtful conversation. Thank you for reaching out to us. Notice the tone in this. I want you guys to see the tone in these next emails from the different parties, okay? And interested, what do you guys think about this? Do you guys see anything in this or just whatever? Also want to note that email is horrible for nuance and open conversation. So if there's anything in here that comes off differently than our conversation, Pattie, that is solely a failure in my drafting. Please let me know if something in here strikes you as different than our conversation and let's discuss it. Patagonia has no objection to the relationship between Hydro Flask and Pattie Gonia. In particular, the work described in your email last week. So we have no objection to what you're doing, but we do ask that the parties, one, not use or otherwise display Patagonia's logos. Two, not use the Belwy font in the content that is created, including an example here, since blank asked about this when I called him this afternoon. Three, not use Patagonia in any form on product. So this third one, I can instantly tell you. So you go, okay, we won't use the logos, we won't use the font. Oh, well, now you're saying don't use Pattie Gonia, which is my name. Not my real name, but my name that I'm using. I hope the 3 points above give you a clear sense of where we're coming from and give you confidence to move forward with your partnership and do great work together. If there are any questions as the work progresses, please don't hesitate to reach out to me. Gratefully, whoever. Okay. February 10th, 2022. Email from Pattie Gonia. Hydro Flask Patagonia, Patagonia. Robert, thank you all so much for your handling of this issue and for including us in the discussion. We really appreciate each of you so much. Cannot wait to get things going. Super excited. Patagonia, Win Wiley. Jenny Dugan. There you go. February 15, 2022. Email from Patagonia. Hi all. One clarification addition I should make to this regarding use of Patagonia's logos. Patagonia would ask that the parties not use Patagonia's logos or any substantially similar designs like the mask meme logo we discussed, Patty, that used the mountain silhouette and Bowie font. I think that additional language accurately reflects our conversations, and sorry for not being more clear in the first go at this. As before, I welcome any conversations feedback. I just didn't want to leave my potential miscommunication hanging out there. February 16, 2022, email from Pattie Gonia. Thank you for the clarification, Robert. Really appreciate it and keep note of it. Okay. 27. Despite these communications, Patagonia is informed and believes that Patagonia registered the domain name patagoniamerch.com in September 2024. Afterwards, Patagonia posted silk-screened apparel products bearing the Patagonia brand. So here's some of the products. T-shirts. Okay. After discovering the Patagonia e-commerce store and related Patagonia products, including apparel and stickers, Patagonia wrote to remind Patagonia of the parties' agreement in 2022 and to explore a resolution ensuring that Patagonia would adhere to those commitments. Patagonia's email sent February 10, 2025 is reproduced below, along with Patagonia's response sent February 14, 2025, so 4 days after they sent. Patagonia's follow-up on March 12, 2025, which received no response, is also reproduced below. So you got an email from Patagonia, then a response 4 days later from Patagonia, and then a follow-up about a month later from Patagonia. And this is after discovering the Patagonia's e-commerce store. So up top, we just went through a couple emails where it seems like Patagonia's like, hey, don't do this, this, or this. And Patagonia's like, cool, noted. February 10, 2025, email from Patagonia. Dear Patty, I hope you are well. It has been what feels like a few lifetimes since we spoke in 2022. I'm writing to you now because I saw the recent announcements about product sales of t-shirts featuring the Patagonia branding, as well as more sales of the stickers, including Patagonia's logo. I am writing somewhat more formally this time. This is like, hey, all right, we're good, but you need to listen here. To stress again how important it is to Patagonia that Patagonia maintain their identity as a persona, but not to use that persona in connection with commercial sales or advertising of products. So they're saying, dude, all right. Trademark law requires Patagonia to affirmatively protect its trademarks against all potential infringement, even where the company is aligned with the purpose and goals of Patagonia, the persona. So they're saying, we're aligned with you. We're aligned with climate activism, okay? But even if we are, we have to protect our trademarks. We have to protect what's ours. The logos, the fonts, we have to protect that, even if we agree with your message. And we do. So they're saying, we're not just bad guys saying, we want to shut you down, the little guy. We want to shut down the little guy, right? My take, this very carefully worded emails here. My takeaway from our conversation and email follow-up from 2022 was that while Patagonia admires the climate work Patty does, Patty would, 1, not use or otherwise display Patagonia's logos or any substantially similar designs. 2, not use the Bowie font in content supporting the sales. 3, not use Pattie Gonia in any form or product. The examples I've seen from social media posts include products that implicate each one of these points that I thought we'd agreed upon. So here's this. Dude, look at this logo. Come on. Look at this Pattie Gonia logo. Come on. Right? Here's some more. Advertising the merch. Patagonia remains supportive of your work, but must insist that the Pattie Gonia persona not be commercialized and continue to adhere to the commitments made in 2022. Unfortunately, these latest product sales force Patagonia's hand, and so I'm asking that you discontinue the sales of t-shirts and stickers or any product using Patagonia's branding or design substantially similar to Patagonia's logos. I hope we're able to work this out, so please call me if talking through this would be helpful. So they're saying, yo, come on now, we talked about this, we agreed on this, and here you go. Here's some examples of you doing the stuff that I thought we talked about and agreed on. We're not saying anything legally, but I am telling you a little more formally, come on, we agreed on this. We have to protect our trademark by law, so I thought we agreed on this, okay? 4 days later, February 14th, email from Pattie Gonia. Hi, Rob. Pattie here with my business partner, Jenny, who you met on Zoom. Thanks for the email and concern. What you shared in your previous email was incorrect. What we shared on our call in 2022 was the following. Pattie Gonia, the drag queen and environmentalist, is inspired by a region in South America. It's wonderful that both Patagonia, the brand, and Pattie Gonia, the drag queen, are inspired by Patagonia's beauty. We also shared that any and all references to the brand Patagonia font or brand logo in association to Pattie Gonia was done by a fan as fan art. We have never sold this fan art. We've never sold this fan art, or we've never sold the logo that was done by fan art on any other products. Bringing the conversation to today, the brand Patagonia's communication earlier this week was coincidental timing. We were actually just about to reach out to the brand Patagonia. We wanted to let the brand know that in light of what we're learning about Lost Arrow, we intend to avoid any perceived association with the brand Patagonia. So, this is interesting. This is interesting. They're being formal and legal. Patagonia's we're talking getting a little bit tidbits of emotional arguments here, right? They're saying the brand Patagonia's communication earlier this week was great timing. You reached out to us, great timing. We were actually just about to reach out to you. In fact, to tell you, because of what we learned about Lost Arrow, I'm not going to go into that here, we intend to not even want to be associated with you guys, right? You reached out to us, we were going to reach out to you and tell you we don't want to be associated with you. Lost Arrow, under the brand this is still the email from Pattie Gonia responding to Patagonia. Lost Arrow, under the brand Patagonia's ownership, developed and sold tactical and military gear to U.S. government and police departments across the nation for years/decades. Bit blurry there, as we're still fielding information from former employees. Beyond Lost Arrow's police and military business purpose, we are concerned about the clear cultural appropriation with the name Lost Arrow. Furthermore, the quick sale of the Lost Arrow division during the height of Black Lives Matter does not absolve the brand Patagonia. We were inspired to do research after hearing the words of Patagonia Brand Communications Director Corley in an interview with Your Public Value, where she mentions the consumers are there to hold you responsible to think beyond profit. Consumers have yet to hold the brand Patagonia responsible for not thinking beyond profit with the creation of Broken Arrow, which supports the very people and institutions destroying the planet. The U.S. military is, after all, the world's largest global polluter. It is a disconcerting fact for a company that claims to be in business to save our home planet. So this paragraph here, really to me, I'm not saying it's not important. It's a non-starter in terms of what we're talking about. Here they're explaining why Patagonia is explaining why Patagonia doesn't want to be associated with Patagonia. We're saying Patagonia's brand Lost Arrow is involved with all this stuff. They're explaining why, but it doesn't really fly in the face of any of the logo, font, trademark stuff. So it's information if you care about it, but in terms of what we're talking about here, from here, we will not utilize any references to the brand Patagonia's font and logo. Our upcycled t-shirt, sweatshirts, and clothing merch is a moot point as we have never and will never reference the brand Patagonia's logo or brand. Fonts we used have been one-of-a-kind custom text or purchased Kilimanjaro font. Furthermore, our merch is made out of clothing saved from landfills and screen printed with new designs. However, per the brand Patagonia's consideration, and to make sure there's absolutely no brand association between Pattie Gonia and the brand Patagonia, we won't save any of the brand Patagonia's product we frequently find heading to landfills. Okay? So, Pattie Gonia is saying, we will not utilize any references to the brand Patagonia's font logo, and we won't save any of the brand's product that we frequently find. Okay? In summary, there's plenty of room for us to both play in this play box. We trust the brand Patagonia will stay on their side and we will stay on ours. There are far more benefits to the brand Patagonia if our relationship remains neutral. So this is a little bit pushy language, don't you guys think? It sounds a little pushy to me. Lastly, we understand positionally here and know you're doing your job, likely reaching out at the request of senior leadership, which you're more than welcome to share with them. You communicated with kindness and grace, and that is appreciated. Are you a bit tired? We are too. So, kicking work aside, if you and your family would ever like tickets to a Pattie Gonia show or some merch, we're happy to make that happen. Just say the word. Patty and Jenny. March 12th, email from Patagonia. Hi, Patty and Jenny. Apologies, this has taken some time to respond. I agree with you that we will all benefit if our relationship remains at least neutral. Recognizing that my legal lens has its limits, I'm adding blank and blank to the conversation since Whitney's no longer at the company. Jonathan's our Director of Global Justice and Belonging. Corley is our Chief Impact and Communications Officer who you quoted in your note. Hopefully, among this group, we can find a productive way forward. We are genuinely interested in at least having a neutral relationship, in particular at a moment where the threats to public lands are so acute. Again, they're saying, yes, we want to have a neutral relationship, especially when we're both fighting for the same thing here. We are both fighting for the same thing here. And we are happy to discuss Patagonia's government business that was discontinued 3 years ago. If you think there are valid criticisms of the company about that business, then by all means share that with your community. So this is the Lost Arrow thing. They're saying, if you think there's issues, please air them out. Share them with your community. They're saying we're not trying to stifle you. We do, however, seem to have a different understandings of where we left things related to Patagonia's trademarks when this last came up. Is there a time next week you'd be available to talk with us to see if we can find a way forward? So they're saying, now Patagonia's saying, look, let's hop on a call and discuss. And I do this in sales sometimes too. When some of these emails, when the wording starts to get a little bit, let's say implied, pushy, or a little bit harsh, rough around the edges, wording you can see kind of people getting a little bit more, you go, let's take this on a phone call, right? This isn't legal. When this goes legal, then it's all legal. Well, you go, let's take this on a phone call, see if we can resolve this. We're on the same side. That's what Patagonia is saying. We're on the same side. We're trying to protect what we created years and years, decades ago, okay? Talk with us, see if there's a way forward. 29. While Patagonia's response stated that clothing merch is a moot point, Patagonia has restocked the Patagonia products at the patagoniamerch.com e-commerce store and has released additional products and Patagonia branded content. So Patagonia in the response said, oh, the merch is a moot point. We're not, don't worry about that. But Patagonia is saying, well, wait a minute. You said it's a moot point, but we see that you've been restocking it. Patagonia also began using the Patagonia brand to promote a tour of theaters and arenas. Patagonia continues to use and display Patagonia's logos. Defendant Entrepreneur Enterprises, DBA Patagonia Productions, formally confirmed the intention to commercialize the Patagonia brand contrary to the parties' 2022 understanding by filing an application, serial number blah, to register Patagonia as a trademark for a wide array of goods and services, many of which are already provided by Patagonia. So this is, look, they're saying, you filed for the application to formally commercialize and monetize this brand, and we've had multiple conversations. Here's emails. We've had talks, multiple conversations that we thought we had an understanding that you're not going to make money from this, right? And here's why. It's confusing. We've built years building our name. Customers associate our logo with this, blah, blah, blah. You're going to confuse people, and I thought we had an understanding, and you're kind of going around that, okay? 31. Contradicting Patagonia's representation that she will not utilize any references to the brand Patagonia's font and logo, Patagonia celebrated a milestone number of Instagram followers on October 2025 by displaying the copycat Pattie Gonia logo on gloves, replicating Patagonia's famous P6 logo. So here's the logo on the gloves. Right? Guys, come on. This is like, I know it says Pattie Gonia, but in my opinion, that looks like the Patagonia logo. Come on. In a TED Talk address, Pattie Gonia exclaimed that many members of the audience were wearing my merch. She then proceeded to announce that Patagonia vests are indeed very TED drag. Right here. So they're saying you even said at a TED Talk, you said Patagonia vests are TED drag, right? On November 2022, 2025, Pattie Gonia attended an event hosted by Out Magazine. At this event, Pattie Gonia wore an outfit made from the transgender pride flag, featuring a replica of Patagonia's famous P6 logo with the Pattie Gonia trademark. So here we go, right there. Pattie Gonia. We can clearly see that. I mean, can we not see that, guys? Come on. Okay? And then the TED Talk thing was after. The Pattie Gonia trademark is nearly identical to the Patagonia wordmark. True or false? Come on. The logo on which Pattie Gonia has displayed the Patagonia trademark is nearly identical to Patagonia's P6 logo. The full range of defendants' Patagonia's products includes products and services that are identical to and compete directly with Patagonia's products and services. They're saying, dude, this looks exactly the same as our stuff, and you're putting it on your products and selling them. Patagonia's use of the Patagonia trademark and promotion and sale of the Patagonia products has already caused confusion and will cause a likelihood of additional confusion amongst consumers regarding the source of Patagonia's products, or whether Patagonia has sponsored, licensed, authorized, or is somehow affiliated with Patagonia. They're saying, we've got this logo, you're using our almost the same logo, how can people not be confused and think we're not together? The logo's too similar. 36. Patagonia began using the Patagonia trademark long after the Patagonia trademarks became famous. They've been doing this for years. Okay, the Patagonia trademark and Patagonia products are likely to dilute Patagonia's famous and distinctive marks by diminishing their distinctiveness and singular association with Patagonia. So they're saying, if you're going to dilute and diminish, you're going to make two brands out of one logo, and so the image that customers have developed of us over the years, you're going to dilute that into something else, and that's harmful to us, right? Patagonia's further use. Patagonia has no alternative but to protect its goodwill and famous trademark. By no alternative means we don't want to do this. We've had these conversations. We've had these discussions. We've tried to talk. No alternative. Obtaining an injunction against Patagonia's further use of the Patagonia trademark and related designs. Patagonia's transformation into a commercial enterprise is not the first that Patagonia has had to stop in order to protect its brand. These range from parties who, for example, have misused Patagonia's goodwill to sell products or services under Fratagonia, Catagonia, Patagonia designations to offer to others offering Petrogonia and Gatagonia merchandise. So they're saying this isn't the first time we've had to shut some stuff down, okay, because they've been using our logo. Protection of Patagonia's brand requires action, whether the brand or logo has been misappropriated by supporters of the oil industry, paramilitary organizations, or supporters of Patagonia's core initiatives. Just a few examples are shown below of other similar infringements that, if unabated, would cause the same kind of harm to Patagonia's brand as Patagonia's enterprise. So they're saying, we're not trying to shut down a climate activist. We've had to shut down all these other industries, oil and gas, all these other industries that have used our product. It's our duty, it's by law, we have to go fight this, or to fight our trademark, to keep our trademark. So they're saying, when this blows into we're trying to shut down a climate activist, we're not. Our message is the same. They're saying we're talking about the same thing. And look at, we've had to shut this down because you guys are using our logo and our likeness, right? Not because we're trying to silence the little guy. And here's examples of that where we've had to go into different industries and shut these guys down, right? And so here's Patagonia, looks exactly the same. Patagonia. Here's a gun thing that looks like, here's Patagonia with a paw in it. Just a little minor changes to the logo and then post it, right? Send it, baby. We got ourselves a new logo. Given Patagonia's failure to follow through on the limitations of the parties had discussed, working instead to develop and own trademarks for a Patagonia enterprise, Patagonia believes that Patagonia will not stop compromising Patagonia's famous brand unless defendants are restrained by the court. So they're saying, we talked about this, we had an agreement, and then Patagonia took that agreement and is slowly but surely infringing and going, now we're going to do this, we're going to do this, we're going to make the logo, now we're going to do this, now we're going to commercialize it, now we want a trademark on it. So they're saying, you're not following through on our agreement, and we don't think you're going to stop because all we see is you moving forward, right? While Patagonia only seeks only nominal monetary damages, only $1 they sued for, the harm Patagonia has caused and will cause to the Patagonia brand is irreparable and cannot be remedied by money damages or other remedies short of an injunction. They're saying, you're not causing us monetary damages. It's this brand image that we've built through this logo, not through this logo, but through our company. And when people see the logo, they associate that logo with the entire thing, right? I mean, think about it, guys. When you go buy a pair of Jordans, the Jordan logo, the Nike logo, you associate that with a certain product, right? Be that as, you know, people who like Nike go, oh, I like Nike, so I see Nike, I buy. Or who hate Nike go, I hate Nike. You associate the logo with, it's not just a simple picture. It may be when it's us, you know, someone with 1,000 followers making a logo. But once it's a huge worldwide multinational company, it becomes an image, right? Well, yeah, Patagonia seeks nominal damages. Unless Patagonia is restrained by the court, Patagonia will continue expanding and causing harms by, among other things, A, depriving Patagonia of control over how and what purpose its trademark is used, B, confusing and deceiving consumers about who's producing, sponsoring, or authoring the Patagonia products, C, causing the public to falsely associate Patagonia with Patagonia, D, causing the public to falsely believe Patagonia has collaborated with Patagonia, E, irreparably harming Patagonia's goodwill and compromising the capacity of Patagonia's famous Patagonia's trademarks to differentiate its products from those that others have created. F, irreparably harming Patagonia's licensing and collaboration programs and its ability to control its brand partnerships and associate itself with selected partners who are specifically aligned to Patagonia's company mission. And 40, for all these reasons. So they're saying, dude, if we let you do this, we have no control. You have a logo that looks exactly like ours. You have font that looks exactly like ours. We have no control what you're going to go and do with that, right? We don't, you might put that on what, we don't know what you're going to do with it, right? For all these reasons, Patagonia is entitled to injunctive relief against Patagonia and to order directing the USPTO to refuse registration of the Patagonia trademark, right? So they're saying for all this we listed, we have to fight back against this, okay? First claim, federal trademark infringement. First claim, 41. Patagonia realleges and incorporates by reference each of the allegations contained in paragraphs 1 through 40 of this complaint. 42. Patagonia has used in connection with the sale, offering for sale, distribution, or advertising of its products bearing the Patagonia trademark, words and symbols that infringe upon Patagonia's Patagonia trademarks. Patagonia has also applied for a trademark registration that, if the registration were allowed, would involve the use of Patagonia trademark on goods and services that would infringe on Patagonia's rights and registered trademarks. They're lining this out. They're saying if you guys allow this trademark, that Patagonia is going to put our logo on all this merch and products and all this stuff, it's going to infringe on what we have trademarked. These acts of trademark infringement are likely to cause confusion, mistake, or deception and are in violation of 15. As a direct and proximate result of Patagonia's conduct, Patagonia is entitled to recover nominal damages in the amount of $1, and an award of attorney's fees. But the attorney's fees, and I think Patagonia has responded to this and said, yeah, $1, but those attorney's fees are going to be millions. That's interesting. But right here, they're saying we're suing you for $1 and the attorney's fees. 45. Patagonia is entitled to injunctive relief pursuant to 15 U.S.C. that requires Patagonia to stop I. use of the Patagonia trademark I. 1. And any other mark or design similar to Patagonia trademarks. 2. Any further action in pursuit of defendant's trademark application. And 3. To a directive to the USPTO that the application must be refused. So they're saying, you guys cannot grant this trademark, otherwise this person's going to put all our logo on everything and use it for their financial gain. Right? Second claim, federal unfair competition. Patagonia realleges and incorporates by reference each of the allegations contained in paragraphs 1 through 45 of this complaint. Patagonia's conduct as alleged in this complaint constitutes the use of symbols or devices tending falsely to describe the Patagonia products within the meaning of 15 U.S.C. Patagonia's conduct is likely to cause confusion, mistake, or deception by or in the public as to the affiliation, connection, association, origin, sponsorship, or approval of the Patagonia products to the detriment of Patagonia and in violation. Patagonia also has applied for a trademark registration that, if the registration were allowed, would involve use of the Patagonia trademark on goods and services in a manner that would likely cause relevant consumer confusion about the source of Patagonia's goods or an association or affiliation between Patagonia and Patagonia. So they're saying the same thing again here. We're saying it's unfair. When people see your logo, they're gonna associate it with us, right? As a direct and proximate result of Patagonia's conduct, Patagonia is entitled to recover nominal damages of $1. $1, that's significant because Patagonia gets to say, we are on the same team and this isn't about money. If people try to say this is about money or silencing the little guy, Patagonia is saying this is not about money, we're suing you for $1 and we are on the same team with all this stuff we've listed. And an award of attorney's fees. Patagonia is entitled to injunctive relief pursuant to blah blah, use of Patagonia trademark, any other mark design similar to Patagonia trademarks, any further action in pursuit of defendant's trademark application. Third claim, federal dilution of famous mark. Patagonia alleges and incorporates by reference each of the allegations contained in paragraph 1 through 49. Patagonia trademark is distinctive and famous within the meaning of Trademark Dilution Revision Act of 2006, 15 U.S.C., and was famous prior to Patagonia's adoption of the nearly identical Patagonia trademark. Patagonia's conduct and trademark application is likely to dilute Patagonia's Patagonia trademark by diminishing its distinctiveness in violation of trademark dilution. So they're saying right now that Patagonia logo is distinctive. People associate it with one thing, their company. And this, if Patagonia is allowed to do this, that's going to dilute who people associate that logo with. As a direct proximate result of Patagonia's conduct, Patagonia is entitled to recover nominal damages of $1 and attorney's fees. Patagonia is entitled under blah blah to injunction that requires Patagonia to stop using, same thing, Patagonia trademark, any other similar designs, right? Fourth claim, trademark infringement and unfair competition under California statutory law. Patagonia realleges and incorporates by reference each of the allegations. Patagonia is the owner of numerous registrations for the Patagonia trademarks as well as common law rights in those marks. Patagonia, take a drink every time you hear Patagonia or Patagonia. God, an hour plus long video. Whew. Patagonia is using and has applied to register a trademark that infringes upon Patagonia's Patagonia trademarks without the consent of Patagonia and in connection with a sale, offering a sale, distribution, advertising. Patagonia's infringement of Patagonia trademarks is likely to cause confusion, mistake, and deception as to the source of origin of Patagonia's offerings. So they're saying people might think that, yeah, it's a slightly different brand, but obviously it's because it's got the logo that you're getting the things from Patagonia and then selling them on. Origin of Patagonia's offerings. Patagonia used the Patagonia trademark to enhance the commercial value of Patagonia's offerings. They're saying you're using this logo because it's helping, it's recognizable, so it's helping you sell. Patagonia's acts violate Patagonia's trademark rights under California Business Professional Code. 61, Patagonia's conduct as alleged in this complaint also constitutes unlawful, unfair, or fraudulent business acts or practices and unfair, deceptive, untrue, or misleading advertising within the meaning of California Business Professions Code. Patagonia is entitled to nominal monetary damages of $1 and an injunction requiring Patagonia to stop use of the trademark, any further action pursuit. Okay. So that's the fourth claim. Without injunctive relief, Patagonia has no means by which to control the continuing injury. So they're saying we can't control, if you let Patagonia use this logo and trademark, we can't control what happens with it. Fifth claim, trademark dilution under California law. Patagonia realleges incorporates. Patagonia owns valid and protectable rights in its Patagonia trademarks. The Patagonia trademarks, registered marks in the state of California, are distinctive and famous within the meaning of the California model in that they are household brands in California and were famous prior to Patagonia's adoption of the Patagonia trademark. So they're saying this isn't just some random brand. This is a big brand that's been a household name, a household product in California, right? Patagonia's acts and trademark applications are likely to dilute the distinctive quality of the Patagonia trademarks. It's saying the same thing here. Dilute the distinctive quality of Patagonia trademarks. Patagonia's acts therefore constitute trademark dilution because you're going to make it less distinctive. One logo is going to, in the consumer's mind, it's going to be related to two brands now, not one. So you're diluting the distinctiveness, okay? And then entitled to nominal damages, and the same thing. You stop using the trademark, stop using similar designs. The application by the USPTO must be refused without injunctive relief. Patagonia has no means by which to control. Sixth claim. Realleges, owns valid. Conduct is likely to cause confusion, mistake, and deceives the source of goods. So this is trademark infringement. Patagonia infringed Patagonia's trademarks with knowledge and intent to cause confusion. So this is interesting because it's knowledge. So they're saying Patagonia obviously knew that this logo is the Patagonia logo. Unless restrained and enjoined, the conduct of Patagonia will further impair the value of Patagonia trademarks and Patagonia's business reputations and goodwill. Patagonia has no adequate remedy at law, right? So unless restrained, unless this is stopped, that this is going to further impair the value of the trademarks, right? So they're saying this is going to devalue our trade. If anybody can just take our trademarks and keep using this without stop, if the courts don't stop this, that devalues our trademark, right? And we have no adequate remedy. Patagonia is entitled to nominal monetary damages, $1, and then Patagonia stop using the trademark or design similar without injunctive relief. Patagonia has no means by which to control continuing injury, right? Ability to control its marks. Okay, prayer for judgment. Wherefore, Patagonia prays that this court granted, I don't think it's praise, that this court granted the following relief. Please, court, please grant this. 1, adjudge that defendants have infringed on the Patagonia trademarks in violation of Patagonia rights. So the court, they're saying, the court, please, we hope you see that the defendants, Patagonia, has infringed on the trademarks based on Patagonia's rights under 15 U.S.C. They've infringed the Patagonia trademarks in violation of California law. They've infringed Patagonia's common law rights. They adjudged that if defendants' trademarks applications were allowed to register, the goods and services Patagonia sells under the mark infringe the Patagonia's statutory and common law trademark rights. The defendants have competed unfairly with Patagonia, so Patagonia, the company, wants the court to acknowledge and grant the relief on all these following things. Competed unfairly with Patagonia. Competed unfairly with California law and Patagonia's rights. Likely to dilute the Patagonia trademarks in violation of Patagonia's rights. Adjudge that defendant and their agent, employees, attorneys, successors, assigns, affiliates, and joint ventures, or any person in active concert or participation with them, and or any person acting for, with, by, through, or under them, be enjoined and restrained at first during the pendency of this action, and therefore permanently from. So they're saying all these defendants and people with them in concert or participation, people involved with them, stop, to make them stop manufacturing, producing, sourcing, importing, selling, offering for sale, distributing, advertising, or promoting any goods or services to display any words or symbols that resemble Patagonia trademarks, because they're likely to cause confusion, mistake, or deception. So same thing they've been saying. We're close here, guys. Is not authorized by or for Patagonia, including without limitation. This manufacturing of this product is not authorized. Any product or service that bears the Patagonia trademark or any other approximation of Patagonia's trademarks by using any word, term, name, symbol, device, or combination that causes or is likely to cause confusion, mistake, or deception as to the affiliation or association of defendants or their offerings with Patagonia, or as to the origin of defendants' offerings or any false designation of origin, false or misleading description of representation of fact, or any false or misleading advertising, likely dilution of Patagonia's trademark. So this goes back to the dilution. They don't want the logo to be associated with more than just their brand, and they have no control of what that association is going to become, right? They can control what Patagonia is doing. They're the business, but they can't control what someone else is doing. And if they have their logo and consumers are associating that logo with another business, Patagonia has no control, okay? Further infringing the rights of Patagonia in and to its Patagonia trademarks or otherwise damaging Patagonia's goodwill or business reputation, further diluting famous trademarks, otherwise competing unfairly with Patagonia in any manner, continuing to perform any manner whatsoever, or of the other acts complained of in this complaint. 9. Order that the registration of application must be refused. So they're saying you have to say all these things are true and you have to refuse the trademark application that Pattie Gonia put in, right? Adjudge that defendants are prohibited from applying to register any trademark or service. So the courts need to say that Pattie Gonia can't apply anymore for trademarks that are likely to be confused with Patagonia's trademarks. Adjudge that defendants be required to immediately to deliver to Patagonia's counsel their inventory of infringing products, stop selling them, and give us what you have, without limitation, patches and any other products, packaging, labeling, advertising, promotional material that are in their possession or subject to their control, and infringe Patagonia's trademark as alleged in this complaint. So you haven't stopped selling them. You've kept making them. You've made more stuff, and you keep selling it. We want all that stuff, right? Because we don't know. We can't trust that you're not going to do it. We can't trust that you're going to do what you say. Okay? 36 is the last page here. Judge defendants within 30 days after service of the court's judgment be required to file with this court and serve upon Patagonia's counsel a written report under oath setting forth in detail how defendants have complied with the judgment and injunction, right? So defendants 30 days, so after the court serves, then the defendants, Pattie Gonia, has to file with the court within 30 days to explain how it's complied with this judgment. And that Patagonia recovers from defendants the $1, and that Patagonia be awarded its cost and disbursements incurred in connection with this action, including Patagonia's reasonable attorney's fees, investigative expenses. A judge that all such other relief be awarded to Patagonia as this court deems proper, right? So, guys, this is very interesting to me, and it's looking like, because Pattie Gonia has responded to this. If you guys want me to go to the response, tell me, and I'll try to do it. I'll make some comments on it. But basically, the public issue here is that on its onset, if you just look at it, it looks like Patagonia is a big brand that's trying to silence and crush the little guy. But if you dig a little further into it, it's looking like Patagonia is saying, dude, we're aligned here. Our messaging is the same. We're on your team as far as what the message is. What we don't like is for you to take our logo that we've designed years and decades ago and have been building our brand, and now that logo is associated with our name, take it and do whatever you want with it, right? And basically, we have no control over what you're doing with it. So very interesting to me. If you guys want me to cover more stuff on this, like Pattie Gonia's response and all that, let me know, and let me know your thoughts on this case either way. So there you go. There's the full lawsuit for the Patagonia versus Pattie Gonia case, and we're going to be back with more videos, guys.